So good morning, everybody. As Lois said earlier, my name is Alison Ward. I'm a lawyer at the Community Legal Assistance Society, and I run the Advocate Support Line. And I'm here today to give you a brief update about welfare law in BC over the past year. I do have a couple of handouts that should have been making their way around the room. One is Welfare Law Update, October 2018 to October 1st, 2019. And then there's a separate one, which is the Welfare Law Update for changes expected later this year and early next year. So as you can sort of tell from those titles, what I'm going to be doing is looking back at the year just gone by to see what changes have taken place, and then looking forward to some other changes that we're still expecting to come into force later this year or early next year. So, like Danielle, I have about 20 minutes to do all of that. So it's going to be a very high-level overview. And as you all know, I think that particularly with a fairly complicated statute like the welfare statute, the devil is definitely in the details, which is why I provided a handout, because I've given section references in the more detailed section of the handout and a little bit more information about what some of the changes actually mean. So I don't have time to go through everything in the year gone by. What I'm going to do is, you have the handout to take away with you. I'm going to go over some of the highlights, some of the more important changes that have happened in my perspective over the last year. So I wanted to, for some of you this will be a recap, and for some of you it may be new. So I wanted to remind everybody that we had an interesting change in December of last year regarding crisis supplements. The monthly crisis supplement for food was limited to $20 a month. That was raised to $40 a month. But the more interesting change was that the yearly cap on the total amount of crisis supplements that somebody could receive in a 12-month period was eliminated. So it used to be that you could only receive up to a maximum of twice your benefit rate for a running 12-month period. That cap is now gone, which means for certain crisis supplements, and I'm thinking particularly of hydro, our fuel crisis supplements, there is no dollar amount, no limit on the amount of a crisis supplement that can be issued. So that's an important change to bear in mind. Also earlier this year, there was an introduction of a new policy. This is the only policy change I'm referring to in the handout. Everything else is regulatory and upcoming act changes. But there was a new policy introduced which formally recognizes what's called an Estoppel defense to overpayments. So if the ministry alleges that somebody's received an overpayment of benefits, I'm sure many of the people in the room have seen situations where the overpayment arguably arose because of ministry error. The client told the ministry everything about their situation. The ministry didn't calculate things quickly or didn't process some of the information that was given to them. And as a result, they paid the client too much. Generally, the answer to that has been, too bad, so sad, you still have to pay it back. So what this policy does is formalizes a defense to an overpayment called Estoppel, which can arise where a client's received an overpayment of benefits as a factual matter. It was an overpayment. The overpayment was caused by ministry error. And I've included a copy of the policy attached to the first handout because I think it's quite interesting to read some of the examples of where they say that ministry error can be found. So ministry error could be an explicit statement by the ministry that the person was eligible for the benefit that they received in what turned out ultimately to be a mistake. Or it could be an implicit statement by the ministry, so where they just they implicitly make it seem that everything's okay because the client's given the ministry all the information the ministry needed to determine whether or not the person was eligible for the benefit, and the ministry erred and paid them benefits despite that. So that can be seen as ministry error as well. And the overpayment due to ministry error has resulted in the recipient relying on the funds to his or her detriment. Basically, they spent the money they got. And the policy recognizes that basically in any case when you have someone on benefits living under the poverty line, It's generally accepted that a person in receipt of assistance will have detrimental reliance on the ministry in the sense that they'll adjust their expenses and spend any additional money that they're getting on basic necessities of life. So I think that policy will be very interesting to see how it plays out. So any case where you have an overpayment allegation and it appears that there was ministry error involved, you want to remember that policy is there, and of course you're free to call me with questions if you want to try and raise it in your case. Just a reminder too that we had an increase in support rates earlier this year, $50 increase for all forms of benefits. That was effective April 1st. And then of course there was a whole raft of changes that took place in July of this summer. Some of which were changes that had been recommended by the poverty reduction strategy that came out in March of this year. There's other recommendations in that report that have yet to be implemented and will be seen in some of the upcoming changes later this year. So one I wanted to highlight is that the definition of transient has been repealed. So a transient used to be defined as somebody that the ministry, so somebody who was single, no kids, and who the ministry considered was basically passing through town, was applying for welfare in a community where the ministry didn't think they intended to make their permanent home. A person in that situation before July 1st was not eligible for shelter benefits. They were only eligible for the cost of hostel and food. And also they weren't eligible for any health supplements, any earnings exemptions, any moving costs. So very restricted eligibility. All of those limitations have now been removed. The definition of transient is gone. So somebody who may or may not be passing through town is eligible for all of the benefits that attach to whatever form of welfare benefit they're eligible for, if it's income assistance, whether it's PWD. And then here's the big one. I think many of you have heard that the criteria for PPMB benefits for people with a persistent multiple barriers to employment, changed very significantly on July 1st of this year. That was a change that was a very long time coming. Changes to the PPMB definition were first recommended by an ombudsman's report called Last Resort about the welfare system in 2009. And finally, 10 years later, we see basically the changes that the ombudsperson, met some of the changes that the ombudsperson recommended in 2009. So the changes are really large. Essentially, it's a new, pretty much a brand new definition of the criteria you have to meet to be designated as PPMB. Really importantly, before July 1st, addictions could not be considered a health condition that qualified you for PPMB benefits. Addictions can now be considered as a health condition. So just with that change alone, it means that many clients who may have previously applied for a PPMB and been refused may now be eligible. So think of your caseload, think of clients who you might be recommending that they should be applying for PPMB benefits now. Another big change is that you used to have to be on some form of welfare for at least 12 out of the last 15 months before you could apply for PPMB designation, and that is gone as well. So currently you have to be receiving income assistance or hardship assistance before you can apply for PPMB designation, but you could apply for income assistance, you're accepted, 2 weeks later you can start your PPMB designation. There's no minimum period of time that you have to be on assistance before you can apply for PPMB designation. The health condition that you have to qualify for PPMB has to have continued for at least 1 year and be likely to continue for at least 2 or more years, and has occurred frequently in the past year and is likely to continue for at least 2 more years. So not too much change there. What has changed is that a big change is that the old employability screen is gone. No more question of whether you score under 15 or over 15. So that thing is gone. Now you have to have the ministry agree that your health condition is a barrier that seriously impedes your ability to search for, accept, or continue in employment. And you have to face a circumstance that the ministry agrees is a circumstance that seriously impedes your ability to search for, accept, or continue in employment. And there's a list of things that they specifically consider to be one of those circumstances. But that list is not exhaustive. It means other things can be considered to be circumstances that would help you qualify for PPMB benefits. So I'm looking at page 5 of the handout. Have a quick read through that list. So if you're homeless or you've been homeless in the last year, you're experiencing domestic violence now or in the past 6 months, you need ESL training. You don't have a grade 12 education, you have a criminal record, you don't have basic employment skills, you've accessed emergency health, mental health, or addiction services multiple times in the last year, you're a convention refugee, or you've been found to be a refugee in the last 2 years, or you're still having your refugee claim determined, or you are a former child in care with MCFD or with the equivalent ministry in another jurisdiction in Canada. So those examples are quite broad, and like I said, they're just examples. So other things can also be considered by the ministry to be circumstances that help you qualify for PPMB benefits. But I think that list that sets out very specifically that those things do count is quite helpful for many clients that might be applying for the PPMB designation now. Did I say that there's a new application form? Because there is a new PPMB application form. Right. I'm going to move quickly over the next few. We saw a change in the asset exemption for cars. So for people on income assistance or PPMB benefits or applying for them, there's no cap now on the value of a car and the amount of equity you can have in your first vehicle. Makes it very simple. The asset exemption level for people on income assistance and PPMB also rose in July. Used to be $2,000 for a single person for income assistance or PPMB. That's risen to $5,000. And for family units of 2 or more, for income assistance or PPMB benefits, it's now $10,000. The moving cost supplement was also expanded. There used to be a lot of geographical restrictions, like you could move from one municipality to an adjacent municipality and have your moving costs covered for certain reasons, but you couldn't move 2 municipalities over. There were a lot of distinctions that were drawn. So basically now, moving costs can be available for a move anywhere in BC as long as you meet one of the specific criteria that the ministry can cover moving costs for. Storage costs can also be included now in a moving cost supplement if the ministry thinks you need to have your storage paid for in order to preserve your belongings. Because otherwise, if you lose your stuff, you're just going to be going back to the ministry to ask for a crisis supplement to help buy new furniture in the future. So there's some recognition that storage costs can be key in actually helping a person retain their things as they're going through a move. The identification supplement was broadened. Used to be you could only get an identification supplement if you were on hardship assistance and you needed the ID in order to become eligible for regular assistance. It was like a very narrow little criteria. So now identification supplement is available to everybody on welfare. So if you need the ID to access services in BC, or for another similar purpose. And some of the examples given in the policy manual of what can be considered another similar purpose are again quite broad. They include like if you need ID to apply for a job, or in order to go to school, or to participate in community activities. So that's quite a broadening of that supplement. And finally, for changes gone by, we have the room and board rate increased for people who receive room and board from a parent or adult child. That rate used to be lower than the rate somebody could get if they received room and board from a stranger. Now the rate is the same for anybody in a room and board situation in the province, whether or not they're living with an adult child or their parent. Okay, so those are the changes that have already happened. From there, I want to move on to the changes that we're looking forward to. So we're moving now on to the second handout that I've watermarked expected changes to help you remember that these haven't happened yet. And I thought I was so organized. I got my handout into Lois last week on, I think it was Wednesday. And you'll see in it I say, the legislation for these changes is still being drafted, so the information below is my best guess at what the changes may look like. That's still kind of true, except that yesterday, the government passed a bill at first reading. So we do now have a little bit more information about what the changes may look like. However, this is just first reading. As you know, bills go through 3 readings in the House before they're passed, so it's always possible that amendments can happen. We don't really know, but it gives us a better picture. Thankfully, my guesses were mostly right, but there are 3 surprises, 3 things that I don't have in my handout that are included in the bill yesterday, so I'll talk about those briefly. So first of all, I'm just going to look at the summary because I don't have too much time left. So reading through the bill from yesterday, the plan is to completely eliminate the 2-year financial independence test for all people applying for welfare in British Columbia, which I think is a very positive change. So 2-year financial independence test will be eliminated. Secondly, the definition of spouse is to be changed. The only change there is that currently, if you're in a common law, currently the ministry can't deem you to be somebody's spouse. If Danielle and I are roommates, they can't consider deeming us to be spouses until we've lived together for at least 3 months. The change will be that that period of time is being extended to 12 months. So they couldn't allege that we were spouses unless we'd already lived together for 12 months. It's to bring it in line, they say, more with the CRA kind of definition of spouse. Another, I think, very positive change is that the requirement that welfare recipients apply for CPP early retirement is being eliminated. So that is also in the draft from yesterday. That's very punitive because, you know, if you apply for CPP early retirement at age 60, your CPP retirement rate is for the remainder of your life 30% below what it would be if you'd waited to apply for retirement benefits at age 65. So that's a very positive change. Supplements for people who receive hardship assistance are going to be improved. This is a regulatory change. So currently people on hardship are not eligible for supplements for addiction treatment and special care. The plan is that those restrictions will be removed and they will be eligible for those supplements in the future. The limit on the number of security deposits is going to be removed, and a pet damage deposit supplement is to be introduced, equivalent to payable in the same circumstances under which landlords can require a pet damage deposit under the Residential Tenancy Act. And final regulatory change that we're expecting is that crisis supplements for housing-related costs will be increased. So currently, you can, if you have a housing-related cost other than hydro, fuel, water, if it's, say, for rent, you have arrears, you've got an eviction notice, the ministry can only issue a crisis supplement up to your shelter rate for your family unit. The plan is to, so $375 if you're single. The plan is to increase that so that the crisis supplement can then be for your benefit rate for the month, so $760 if you're single on income assistance. So I'm out of time, but there were 3 surprises in the bill yesterday. So things that weren't in my handout that I just want to talk about super briefly. They are changes to Section 10, information and verification. So currently, if the ministry asks you to confirm your proof, give us these documents to show that you're eligible for welfare or to give us a bank account, and you're not able to provide the documentation that they ask for, you can be cut off benefits. So what they want to do is introduce a discretion so that instead of cutting the person off benefits, if the person is homeless or at risk of homelessness, there can be a reduction in their benefit rate instead of complete ineligibility. There's no details about how much the reduction would be or for how long that'll be in the regulations, but that's the change, the proposed change to the Act. And one that's very interesting that is to do with the Employment and Assistance Appeal Tribunal, changes to evidence that can be introduced at the tribunal. So currently, you're only allowed to introduce evidence that is in support of the evidence that was before the reconsideration decision maker. So the proposed change is that a panel may consider evidence that is not part of the record as the panel considers is reasonably required for a fair and full disclosure of all matters related to the decision under the appeal. So basically, you would be able to introduce anything that's relevant to the person's issue. PWD application, recon, there was 4 diagnoses, now there's 7. Put in your evidence of the additional 3 diagnoses and their functional limitations. So no change, though, is proposed to the standard of review at the tribunal, so it would still remain whether the reconsideration decision was a reasonable application of the legislation in the person's circumstances or was reasonably supported by the evidence. So who knows how that would play out? It's the proposal. I'm out of time, so I'm going to pass the microphone on to our next speaker, which is Raji. Thank you.